Mr. Chairman, Ranking Member, members of the committee, the chairman invited me to share my thoughts on the conduct of the tax investigation into Hunter Biden. I make my comments on my own behalf as a private citizen and not on behalf of any person with whom or group with which I might be or have been affiliated. When I learned that experienced IRS special agents had felt compelled to report to Congress about the obstruction of their criminal tax investigation, I felt compelled, too, to share my understanding of how things are supposed to work with people who have no reason to appreciate how disturbing the whistleblower's allegations are. Without context and a frame of reference, it's difficult to know sometimes how seriously to take things. In an October 2022 meeting of the Hunter Biden prosecution team, U.S. Attorney Weiss admitted it was not his decision whether to bring charges the investigation had proven should be brought. This directly contradicted Attorney General Garland's sworn testimony 6 months earlier. This was the final straw. After more than 3 years of having his investigation stymied, but nonetheless having proven substantial criminal charges, Supervisory Special Agent Shapley realized he had to come forward. In fact, he had come forward before, internally within the IRS, using the procedures developed for that purpose. He had complained up his chain of command as early as June 2020 about the obstruction he was encountering, but there had been no response. Once Shapley had taken steps to come forward to Congress, Special Agent Joseph Ziegler did the same. It was not the whistleblower's testimony, however, but what followed that compelled me to write. My first Wall Street Journal article was called "Throw Hunter Biden's Plea Deal in the Trash." Given the substance of the whistleblower's testimony, the plea deal Weiss had worked out with Biden was a miscarriage of justice. After that commentary was published, I heard from many people who were similarly appalled at the unfolding injustice. Many were knowledgeable and experienced tax professionals. Perhaps the most commonly commented on aspect of the handling of the Hunter Biden matter was that Weiss had permitted the statute of limitations to expire on prosecuting provable offenses. This was appalling. It is not insignificant that the plea agreement was announced on June 20. Let's review what came just before. On August 19, it became known that IRS employees were going to let Congress know about the obstruction they were encountering. Later, Shapley and Ziegler sat for hours of sworn and subscribed testimony with the House Ways and Means Committee staff. It was expected that the committee would make the testimony public. It did, on June 22. U.S. Attorney Weiss, with his June 20 announcement of a plea deal, beat the publication of the whistleblower's testimony by the skin of his teeth, 2 days. If the whistleblowers had not come forward, would Weiss have brought any charges at all? My second Wall Street Journal commentary was published on July 25. It was called "You'd Go to Prison for What Biden Did." Given what Shapley and Ziegler testified they had proven, and the charges the tax division reportedly had authorized, the plea deal represented serious injustice, not only to law enforcement, but also to people who have been caught up in this system and have suffered the consequences the law provides. I received a great deal of positive feedback on this commentary, too. People understand that for laws to be respected, they must be enforced. The nature of any investigation is the following of leads. That didn't happen here. This team was not permitted to search the guest house of Joe Biden's Delaware mansion and Hunter Biden's storage facility in Virginia, to interview family members and business associates, to examine Hunter Biden's abandoned laptop. By November 2019, the FBI had confirmed the devices were Hunter's and the contents were authentic. But the Hunter Biden investigation must not be viewed in isolation, rather as part of a broad landscape of corruption. Don't forget that a full year after that, in October 2020, FBI officials were telling Twitter that the laptop was Russian disinformation. The whistleblowers tell us that the tax investigation of Hunter Biden was an offshoot of an investigation already underway into an online pornography platform. That is how investigations develop. Agents follow wherever the leads take them, and when they take them in the direction of a new investigation, they open one. Question: if U.S. Attorney Weiss had been in charge of that pornography investigation, would he have blocked the investigation into Hunter Biden's tax crimes? I thank the committee.